I'm Ramona Quillette, and this is my colleague Harrison Magee, and we're here to do Renters' Rights 101 for Realtors. So we're going to go over some of the basics of DC landlord-tenant rights. If there are any questions, please just raise your hand, and we should have time at the end for a discussion if there's some point that you really want to elaborate on. All right?
Okay. Oh, we'll use that for the audience. All right. Okay, so I tend to be dynamic, walk around, so, all right. So, yes. No, we're both attorney advisors at the District of Columbia Office of the Tenant Advocate. All right, so let us get underway. So, brief introduction to what our agency is. We are the DC Office of the Tenant Advocate. We were established in 2005. We're an independent District of Columbia government agency charged with providing legal and education and outreach services to district residents. The purpose of DC Renters' Rights 101 for Realtors today is to provide participants with a brief overview of tenant rights and responsibilities. Future publications in this series will cover each main topic in greater detail. All right. Overview of what we're going to be discussing today. We're going to start with for rental housing, the application process, licensing requirements, leasing, moving in, security deposits and rental receipts, rent control, housing code and relocation assistance, quiet enjoyment and protections against discrimination, followed by evictions, protections against retaliation and right to organize, conversion, tenant right to purchase, and moving out. I'll be doing the presentation for about the first half, and then Ramona will take over afterwards. We will take a brief break at about the halfway point. All right, let us begin with the application process. For a rental application, the landlord may require personal information and payment of a non-refundable application fee. Credit and criminal background checks can be intrusive. They can include asking for identification and social security number, rental history and landlord references, employer reference, and or pay stubs. There are, however, limits to the credit and background check, which we will get to right now. The landlord is allowed to require a cosigner. When you have a cosigner, the cosigner is generally 100% liable. At the same time, cosigners can be prohibited. However, that cannot be the case if it is deliberately aimed at excluding students. When it comes to criminal record screening, landlords may not conduct a criminal background check before making a conditional offer. Furthermore, once a conditional offer has a criminal background check is limited to 48 specific crimes, and the scope of the check is limited to specific crimes committed within the last. I cannot read.
That's a typo. But you do have a handout.
Yes.
And the papers that we gave you.
Yes.
With the criminal background check.
Yes, thank you. All right. Apologize for that. It's different crimes may have different durational requirements there. So, and then also there are rules about if it's a pending accusation. Yes, sure. Oh, we have a question. Yes. Okay, well, No, let me explain. You cannot ask for the information when the person initially applies. If the person fills out the application and otherwise passes the credit requirements and whatever other references, it is only at that point that when a conditional offer is to be made, the landlord or the landlord's agent can ask the person for their criminal history. But no, you can't get around that. That's not a good idea to try to, yes.
Just for clarification, what you're saying, can you, when someone's asking about what's your process,
Yes.
can you let them know that should they get a conditional approval that you will be looking for the criminal background? Can you at least disclose that?
You're disclosing the law, you're just telling the truth. What I would be careful about is making it seem like you're trying to deter people from applying. I mean, if you're just quoting,
Not to detour, but just to be, well, here's a real life situation.
okay,
Okay, because I have a lot of clients, I do a lot of rentals.
yeah,
And what many people are concerned is, one, doing multiple applications and the cost of that. So based on someone's criteria, they make the decision whether or not they're going to go forward or not, based off of what they know they're bringing to the table. So to not tell someone that, I feel like that's dishonest.
okay. Frankly, all right, so here's the thing. I am not, it is not, today's session is designed for legal information, not specific legal advice. Frankly, if I had to give a snap suggestion, is part of the packet, the flyer could be included from the Office of Human Rights. That's a public document. And frankly, when people, even with the best of intentions, start saying things, that's where misunderstandings can occur. And frankly, I wouldn't want to see you or one of your clients end up having to deal with the Office of Human Rights on it. I'm not saying that you have any bad intentions there, but that's just where confusion can occur. So frankly, if in doubt, I wouldn't, you don't have to say that.
So what I want to be clear is that as a landlord or realtor representing the landlord, and someone asks me that question, for me to not disclose that, and then, but that's a part of the criteria for the owner, that if I don't disclose it, and then after, you see what I'm saying?
Yes, okay. Honestly, if someone asks a question, I don't believe it's ever, a person is not obligated to be dishonest about it. It's just, I guess, as few words as possible would be best. It could simply be, DC law allows a criminal background check to be conducted after a conditional offer is made.
Okay.
Yeah, and I would, like I said, quoting the law is quoting the law. If it is designed to deter somebody, that's where you end up, that's where there could be problems there. So,
Hold on. Everyone, I'm going to have the mic, so if you want to ask a question, if you could say it into the mic, that way we will make sure we capture it on the closed captioning.
Quick question, just on this slide, what did you say was the number of years, scope of check is limited to specific crimes committed within the last?
7.
7, okay.
7. But the law does have a variety of technical requirements, so it's important, do follow through on that. Now, when it comes to holding fees, the tenant should.
Hold on, I'm sorry.
Oh, sorry.
So when this law first came out about criminal background checks,
Yes.
we made the decision we just won't do a criminal background check, it's not worth the hassle. But I think I read something and we're concerned about the idea that there are certain crimes that we're supposed to
Okay.
not take a tenant on, and so.
All right. When it comes to housing vouchers, when someone is a tenant when the unit or the tenant, there's a subsidy involved, there may be other rules, and if a federal rule contradicts the local law, the federal rule would probably take precedence with that. But as a general matter, it's not that the landlord is forbidden from conducting a criminal background check. For the sake of argument here, let's pretend there is no subsidy involved and no federal law saying otherwise. The landlord is allowed to conduct a background check after a conditional offer. The idea has been allow a person who would otherwise qualify to at least make it to the offer. And then at that point, the landlord is able to conduct a criminal background check and then disqualify the application if, and only if, they fall into one of the categories on the
Okay,
specific.
but allowed but not required.
What do you mean?
Would the landlord be, you have to run a criminal background check because this guy may be public enemy number one, you know?
The ramifications of not disqualifying someone, that I would say gets beyond the scope of this, because, yes, could someone get sued for not disqualifying someone that they should have? Very possible, but I think that goes beyond the scope of what we're doing today. But that is a very valid question. Oh.
I don't want to get caught up here. I know you have
No, this is-
lots to cover, but I just noticed on the handout that there are exceptions. Are you going to cover elaborate on the exceptions to this?
What do you mean by that?
It says housing providers are exceptions to the criminal background investigation requirement that you're speaking of?
Well, like I said, the exceptions could sometimes involve when someone is applying for a subsidized unit, if it's a public housing building, if it's a project-based Section 8. Like I said, there could be specific programs that allow or require other timing or require disqualification, and we can't cover everything exhaustively. I don't think we're going to be getting into those minutia.
Right, I just saw the one that said if the housing provider lives on the property and it's 3 units or less.
Okay,
And
there are...
was another one, and I wasn't sure about.
All right, so this is what I can say. Yeah, when it comes to some of the discrimination laws, there are, I guess there are thresholds where, depending on the size of the housing accommodation, the number of units, and if the housing provider lives on the unit, they might be accepted from coverage. But again, that is more the exception and not the rule. So I would just, like I said, I would be very careful with that. Again, I mean, I'm not going to tell you how to do your job. But anyway, and by the way, I get that this is a question that especially pertains to realtors. Different audiences are going to be interested in different parts of this. So here, let's finish up this slide. So the tenant should be demanding a receipt. Frankly, you should be happy to give them a receipt for the holding fee and confirm that the holding fee is refundable. The holding fee meaning to hold the unit. Now, requirements for licensing. All housing providers, and when I say all, must possess a basic business license with a residential rental housing endorsement issued by the Department of Consumer and Regulatory Affairs, DCRA. Whether or not there is a business license in place can be verified by visiting the site pivs.dcra.dc.gov. Furthermore, unless the unit is a single-family dwelling, the unit must have a certificate of occupancy, which is issued by DCRA as well, and the same site, pivs.dcra.dc.gov. Finally, the housing provider must be registered with the Rental Accommodations Division, RAD, of the Department of Housing and Community Development, DHCD. That part can be verified by calling 202-442-9505. Tenants can call us to navigate the verification. We can try to look things up, at least on the PIV site. Now, a housing provider's failure to be properly licensed or registered generally does not mean that the lease is null, void, or unenforceable. The lease will likely remain binding on all parties. That being said, there may be consequences regarding whether or not the rent can go up. There can also be fines for not having a license. So just because the lease might be enforced, that does not mean that it is risk or penalty-free to not be properly licensed. When someone applies for a rental, the landlord must provide certain disclosures at the time of application. For example, the basic business license number, the Rental Accommodations Division registration or claim of exemption form, that is RAD Form 1, a copy of the certificate of occupancy, unless one is not required, and the applicable rent for the prospective unit and whether or not the unit is rent-controlled or exempt. Furthermore, presence of indoor mold in the unit or in the common area in the past 3 years, unless mold has been remediated by a licensed professional, a copy of the tenant bill of rights. The list of what must be provided is at DC Code section 42-3502.22. This is something that, in my experience, too many housing providers do not comply with. It is very easy. It is a list. Use it as a checklist. The documentation should just be available and ready to go. Question?
Yeah, these items, we are giving them to the prospective tenant?
Mm-hmm.
Okay, is that given before or after they sign the lease?
It's actually this is before signing the lease. This is, excuse me, I'm just gonna close the door here. The idea is these are disclosures that a prospective tenant is entitled to know about before entering into a contract. So, excuse me. The idea is that these are disclosures that the prospective tenant is entitled to know about before entering into the lease. So no, not after signing. If anything, a copy should be given at the application process. A copy should be given after a lease is signed. And furthermore, this isn't on the slide, but under section 222, a tenant is entitled to this information upon request, and the landlord must, it is not optional, the landlord must provide this within 10 business days of the request, and if it's been 12 months, at no charge to the tenant. So this is not the kind of thing that someone wants to be caught not having.
Also, if you would like a copy, like a form that you can just use, the Department of Housing and Community Development has one on their website.
Mm-hmm.
Yes. Yes.
This is just something that is so straightforward to comply with. There is no reason, is there a question or technical issue? All right, next slide. We're still on the disclosures section. If rent control applies, the landlord must also disclose to the rental applicant any pending tenant or housing provider petitions that may affect the rent for the rental unit, a copy of any housing code violation report issued by DCRA within the last 12 months or for any violations that remain unabated, and a pamphlet published by the rent administrator that explains the requirements for rent increases. I'm going to jump in and say, frankly, it may just be easier to give this as a matter of course for all rental units. It is probably going to be more of a hassle trying to parse what's required for what unit or what not. Frankly, I would say a best practice would be just use this. You can use the city form even if the unit is exempt from rent control. You would just clearly say exempt. Question, yes. Oh,
Can you give them, I'm trying to think of what I was going to say.
could you speak into the microphone,
Yeah,
sir?
I'm trying to remember what I was going to say. Because you've got a lot of things here going on.
Yeah.
DCRA violations and mold in the apartment and all that.
Yeah.
Can you give that to them? I forgot what I was going to say now. Oh, at the time, we have a program, a company that helps us. You probably know them. I won't mention them, but they give us all the disclosures, and we usually do it at the time of leases. So we sit down, we go over the lease with them, we give them all the disclosures.
Okay. Here's
Go
the
ahead.
like I said, so here, we have a bias here. We're the Office of the Tenant Advocate. Frankly, I see no reason not to be giving this at the time of application. I don't mean to kill more trees here, but it's worth giving it all up front, because what happens is if a tenant is entitled to certain information that they didn't get upon application,
Right.
that could make your client's life a lot more difficult later. And just because the company, even if you use a company, that should not be a substitute for complying with this. So whatever form you get pre-printed from a company, I would make sure that it covers all the disclosures under this law. The
Yeah,
law,
there's one thing that that the company makes us give them at the time of application, which is really a pain because everyone who walks out with the application has to get this disclosure.
Yes.
So killing more trees, as you say, but that's okay. But then after that, the rest, I think, we technically can do at the time of leasing, right?
again, that's an area where I really don't feel comfortable venturing into. I am going to say, if you can disclose it, you should disclose it. If you don't have to disclose it, that may be something to speak to a housing provider or attorney about. You, and then I see you.
I just had a question and a comment. Does the disclosure have to be in paper form, or can you do it electronically? Because as a practical matter, you want to do that disclosure at application, because you don't want to be sitting down at leasing and then disclosing things, because they may not agree at that point.
Exactly.
So I usually do a text or email with the disclosures attached before application.
Frankly,
So they can make
sorry.
decisions.
I don't have the code in front of me. We're in the 21st century, but unfortunately, some parts of the Rental Housing Act, I believe there's a section that still refers to telegramming stuff. So the thing is, you can't force the person to read it, but if you give it to them and you have a record that you gave it to them, that's just covering your own, you know what. Yes, ma'am.
Okay, my question is, if they're an applicant and then they decide not to, basically I've given all my information to a stranger, and I don't know what happens to it after that.
That information is not private information. I mean, frankly, I'll get on my soapbox here. If I were in charge, this would be information that you could just type in on the internet and already have right there. So, well, there's the database. That's a separate project that I'm not gonna distract the presentation for. So here, I'm gonna go to the next slide on disclosures, and then let's get underway with that. Also, in this, the landlord must make additional disclosures to all new and existing tenants, certain portions of housing regulations, and for rent-controlled units, the last 3 rent increases for the unit and the basis for each of those increases. Furthermore, there are times where if the law changes, if there's an additional disclosure, it may need to be given to existing tenants. And again, I emphasize, even if you believe or your client tells you that the tenant was given this information, the tenant is entitled to ask for it once every 12 months, and it must be given to them without any charge. All right. Another disclosure deals with lead safety, and this is required by federal and district law. All applicants must receive a pamphlet, Protect Your Family from Lead in Your Home, which is a pamphlet issued by EPA, HUD, and the Consumer Product Safety Commission. Also, tenants must receive a tenant lead rights form issued by the DC Department of Energy and Environment, DOEE. The lead disclosure packet.
Well, there's one page that we have to say on there. There's one page where we as a landlord have to sign saying we have papers or we don't, we have knowledge of or we don't.
We're gonna get to that.
That's not this.
No,
This
it's
is
the next
something
slide, actually.
So this is,
That is a pamphlet that actually, there is a pamphlet that actually says, Protect Your Family from Lead in Your Home.
that one I know, that's a booklet.
Yes.
But the tenant lead rights form,
That is a form from DOEE. I don't have the form, I'm not sure if what you're referring to is the same one,
Okay.
but that is, like I said, I get that there is a lot of paper here, but again, have it. I mean, I'm not going to try to argue that it's convenient or not, but the law requires this. Oh, I'm going to go, and also, if the place was built before 1978, it's presumed that the paint there has lead in it. So new tenants shall receive the lead-based paint hazard disclosure form, lead clearance report, if the tenant or member of the household is or becomes pregnant or has a child less than 6 years old. All right, moving on to the lease. We're through the disclosures. The tenant-landlord relationship is established by a contract. Under this contract or lease, the tenant and the landlord, each have certain rights and certain obligations. Now, like all contracts, a lease may be written or oral. A written lease is not required to establish a tenancy. Frankly, to the realtors, why would you ever have a non-written lease? I have yet to think of a good business reason why you would not want one. If there is a written lease, the landlord must provide the tenant with a copy of the lease and all addenda. Furthermore, the landlord may not change the terms of the lease without the tenant's agreement. Another unique part of DC law, after the initial lease term expires, it doesn't truly expire, the tenant has the right to continue the tenancy indefinitely on a month-to-month basis under the same terms, except for lawful rent increases, which is all the more reason why it is important that all the paperwork and compliance is had with licensing and disclosures. Now, key things to be notifying tenants about. Joint and several liability. That is especially for group houses or for roommate situations. Joint and several liability means that all of the tenants are responsible collectively, including for each other, depending on the provision. The amount due at move-in, so the security deposit, the first month's rent, paying the rent on time, when is the rent due, and how to pay it, penalties for late payment. Under current law, a late fee must be specifically provided for in the lease and may not exceed 5% of a month's rent. Any fees in addition to rent, and if the unit is under rent control, separate clearance may be required in order to be able to charge the fees. Services that are included and not included in the rent. For example, water, gas, electricity, trash, climate control, yard maintenance. If the tenant is allowed to sublease or assign, the law allows a landlord to forbid subleasing or assignment. However, that must be clearly provided for in the lease. Yet another reason to have a written lease. If the lease does not say anything about subleasing or assigning, the law is that the landlord is required to provide consent on a reasonable basis and can have criteria, but the criteria must be reasonable. And rather, the landlord may not refuse consent without good reason. Yes?
What's the cap on the amount due at move-in?
I beg your pardon?
What is the cap, if any, for the amount due at move-in?
The cap due at move-in, would be the first month's rent and the security deposit. We will get to security deposits later in the presentation, but a security deposit in DC may not exceed more than the first month's rent. So that's pretty much what can be paid. That is the most that can be required at move-in. Yes?
Just a point of clarification. The security deposit cannot exceed 1 month's rent. So if your first month's rent is prorated because the person moved in middle of the month,
Yes.
that's not the cap on the security deposit. It's the full month's rent.
Yes. Oh, and one other thing. Be extremely clear about what responsibilities the tenants have from the get-go. A lot of times people try to play gotcha and the person says that they didn't know about it at the time. Lay it out there. Be very transparent throughout. Oh, one other thing about to include in the lease, notice of intent to vacate. How much time must the tenant provide and who do they send it to? There are rules about the maximum allowed time to vacate. In the initial lease term, a landlord can require more than 30 days notice that the tenant intends to move out at the end of the term. However, there are certain words that must be used in the lease in order to do so. Those are provided for in the DC code, what to say. All right. Unenforceable lease clauses. Don't put them in there. Don't put them in the lease. That either the landlord or the tenant may terminate the lease for any cause. No. The tenant acknowledges suitability of property for occupancy prior to actual occupancy. Nope. Warranty of habitability is unwaivable. Yes, sir.
That first one, why can't you do that? Why can't
Because
you
that is against the law. DC law, section 42, DC code section 42-3505.01, lowercase a in parentheses. A tenancy may not be terminated simply because the lease expires. The landlord must have a reason, and there, I believe, is it 10 reasons that are caused. The landlord may not simply say, I choose not to renew the lease.
Could you give me that code one more time?
Absolutely. DC code section 42-3505.01, and then in parentheses, lowercase a as in apple. It's section 501A of the Rental Housing Act of 1985. Yes, that is probably one of the most unique parts of DC law. If you practice in neighboring jurisdictions, that may be different. But a lot of landlords get tripped up on that in DC. All right. It is unenforceable to say that the tenant waives the right to void the lease on grounds that the unit is uninhabitable. I was saying right before that the warranty of habitability is unwaivable, and I still mean that. That the tenant waives housing code enforcement. Can't do that. The tenant waives the right to judicial process prior to eviction. No, No self-help. You must go to court. Whoever's doing the captioning, in case we have someone who's using that, the tenant, something else that cannot be done, that the tenant waives the right to a notice to quit for something other than non-payment of rent. Current law allows the lease to waive a notice to quit for non-payment of rent, but for other lease violations, a notice to quit must be provided. And for any other desired termination of tenancy on the part of the housing provider. That the tenant waives a jury trial. Can't do that. That the tenant waives their rights under the Tenant Opportunity to Purchase Act. Can't do that either. That someone other than the tenant can confess judgment against the tenant. That the tenant waives landlord's responsibility for basic maintenance. Again, that is the warranty of habitability. The tenant waives landlord's liability for personal injuries caused by negligence of the landlord. You cannot do that. Furthermore, even if the tenant has renter's insurance, that does not mean immunity from liability for the housing provider. That the lease is terminated in the event of bankruptcy or foreclosure. Not allowed to do that. Excuse me. That the tenant must pay attorney fees no matter what the court decides. The lease cannot provide for that. All right. Clauses that are questionable. Blank spaces in a lease. Put in NA. That way you avoid mischief. That there's no contact information for the landlord. Put down a street and an email address. Also, lease addendums, including house rules, which can be fully incorporated into leases and be enforceable. A clause that says that the tenant has to select a house manager, but that all the tenants are liable for the house manager's actions. Or clauses that require tenants who move out to find new tenants to replace them or still be held liable, group leases. Any requirement that the tenant take responsibility for furniture left by a previous tenant, complex arrangements for the payment of utilities, extensive limitations on conduct with words like immoral and annoyance, the tenant pre-signing a notice to terminate the lease at lease execution, and onerous limitations on subletting. All right. Moving in, there should be a walkthrough and a move-in inspection at the beginning of the tenancy to establish the condition of the unit at the time of move-in. And that should be important to both the tenant and the housing provider. You don't want unnecessary disputes over that. Excuse me. OTA recommends that the move-in inspection occur before move-in or within the first 5 days of occupancy. And take advantage of technology. Use a smartphone or a camera to document the condition of the unit. We typically recommend that tenants take diligent steps to avoid future responsibility for damages caused by others. Tenants should not accept occupancy of a unit that is uninhabitable or not up to the conditions promised. And tenants should definitely demand that the landlord complete significant repairs prior to accepting occupancy. Now, security deposits. If the landlord requires a security deposit, the landlord must not have the value of the security deposit exceed the value of 1 month's rent. Furthermore, the deposit must be placed in an interest-bearing account, and at least annually, the landlord must post notices stating where the security deposit is being held and what the interest rate is for each 6-month period. And provide a tenant who is moving out the same information as above, but for the duration of the entire tenancy. Yes, sir?
You're saying we have to post a notice, is it every year or every 6 months?
Every year. Oh,
Post it where? Just in the building somewhere?
in the building somewhere, frankly, yeah, that's what the law says. I would also email it to the tenant. I mean, there should be nothing to hide here. Yes, ma'am.
I'm trying to frame the question.
Okay,
Okay,
take your time.
so I understand in the district that we cannot accept more than 1 month's security, okay?
That is
So,
correct.
however, in our current time, people have various reasons, things that they're trying to overcome, and tenancy, it's based on credit.
Yes.
Okay, so in other jurisdictions, it's allowed that additional funds can be accepted, blah, blah, blah. My question, although not security deposit, is a tenant allowed to pay additional monies as a good faith that they are credit worthy?
Okay. First of all, I'm not expressing my personal opinion. I have to tell you what, no, I get that. I have to tell you what the law is, not what it should be or what it might sympathetic to certain situations. The law defines security deposit pretty broadly. It says as security for the tenant's obligation. So a good faith payment, if you will. The idea, I'm sure, is your client is thinking that if the tenant stiffs them, that's money that they have. And that strikes me as a security deposit. I would definitely seek advice from a landlord or a housing provider. I would seek legal advice from a housing provider attorney before attempting to take any supplemental funds, if you will. Was there? Yes.
My question was actually similar. It was about basically whether move-in fee is equivalent to security deposit. It doesn't sound like it's exactly the same.
It depends on what you mean by move-in fees.
That's right.
Certain buildings have amenity fees, and if that is part of the rent, now, again, you got to be careful because if the unit is under rent control, if it is a mandatory fee besides the rent, it has to be approved by the rent administrator. So,
But if someone, let's say, does have the cash and they want to ensure they get the unit they want, and they want to pay more, like a more than a security deposit, they want to pay like a insurance type of a fee, or not type of insurance fee, but maybe like a goodwill fee. I don't know what you'd call it.
the law says that that cannot be done. Again, like I said, I got to tell you what the law says, not what it should say, and before accepting such money, because here's the thing, even if a tenant willingly pays more than 1 month's security deposit, they come to our office, we have to advise them that the law does say that the landlord may only demand 1 month's rent. Now, as a practical matter, is a judge going to be very sympathetic? It depends. I mean, again, I have to tell you what the law says, not what it should.
Okay, so with the
Yes.
law saying that, and someone comes to me and says, you know, I really want this place because of my credit, you're denying me. However, if I pay my last month's rent and my first month's rent and my security, will you take me? My answer is no, I can't, because that's the law.
Yes, and I'm afraid I have to. Oh,
Hold on.
okay.
There is a disagreement about that particular question in our office. So I think it's actually a gray area when it comes to last month's rent.
But the devil's in the details, because you said last month's rent. Now, the way that I read the plain language of the law, if the tenant moves out early or causes significant damage, that is money that is being used as security. So, again, I would seek legal advice from a housing provider attorney before attempting to receive, regardless of who offers it first. Oh, yes.
Okay, my question is on the same basis.
Sure.
What if my son is going to college
Mm-hmm.
and he doesn't? I'm going to put him in a apartment versus
Mhm.
college. Can I say I'm going to pay 6 months rent
You mean like in advance?
in advance?
Ugh. All right, Ramona.
Yeah.
Me, I would say to, as a tenant attorney, I would say not, I don't see the law as allowing that. But again, now as we discussed earlier on, the landlord can require or agree to a cosigner.
So this is another place, it's like the last month's rent. I think you're in a gray area, that the tenant can prepay rent and distinguish it from a security deposit. However, when talking to tenants, I never advise them to prepay rent, even if they have difficult circumstances, because then they're sort of at the landlord's mercy if things come up, if the landlord says, oh, actually you have to move out because I'm moving back in, and we'll get into all that later, and then you're looking for a refund. It's just, it gets complicated when you prepay rent,
Yeah.
is all I'm saying. But I don't know that it's necessarily as black and white as you can't accept it, but he is right. When in doubt, consult an attorney who works for housing providers, because we are very much biased, because
Yeah.
we're the Office of the Tenant Advocate.
Because, I do not tell a tenant that the law allows them to pay more than the first month's rent and the security deposit on move-in, and the security deposit may not exceed 1 month's rent. Now, next slide. Returning the security deposit. When the tenancy is terminated, regardless of who terminates it, the landlord must, not optional, either return the security deposit with interest within 45 days after the tenant vacates the apartment. Interest is if the tenancy lasted for at least 12 months. Or, if the landlord is not returning the full deposit plus interest, the landlord must provide a written notice that the security deposit will be used to defray legitimate expenses. And then, within 30 days, the landlord must refund the balance of the security deposit and interest, and provide the tenant with an itemized list of deductions and repairs. It is not legitimate to deduct for anything that was ordinary wear and tear. Ordinary wear and tear is defined as any deterioration that results from the intended use of a dwelling unit, including breakage or malfunction due to age or deteriorated condition. Furthermore, never mind.
I have
We're
a
getting to
question.
it. Yes, sir.
So 45, we usually go with the 45-day thing that we got to get them
Yeah.
an explanation or a refund check or both within
Precisely.
45 days. What's the 30 days
Okay.
after?
The way that the law reads, if the landlord is not returning the full security deposit, for example, there is legitimate damage that was not caused due to ordinary wear and tear, what the landlord is allowed to do is send the tenant a written notice saying, well, whatever the wording, dear tenant, the security deposit is going to be deducted from, and then that's pretty much that. And then you have 30 days from that point.
So within 45 days, I need to notify them one way or the other. Then I
Exactly.
have 30 days to get them the money. So
Precisely.
I have 75 days.
Well, no. 75 days is only if you are legitimately deducting from the deposit, and then there's a balance. So what happens is, let's say that the tenant moves out, and there is clearly damage to the unit, but it's going to take time to figure out how much it costs or will have cost. The law allows the landlord up to 45 days to say the deposit is being withheld, and then 30 days from then to return any balance after the deductions, but that also includes having to account for that. So yes, if there is damage to the unit, if there's a legitimate reason to deduct, then the landlord could have up to 75 days, but that is not 75 days to just return the deposit.
I have one more question. So
Sure,
I
this is
actually-
important.
I actually recently had someone who was subsidized, I think, rapid rehousing.
Okay.
And she moved out like a year ago or something, but she calls me up recently and says she wants, she got her security deposit back.
Okay.
Okay, I think she got all of it. Really.
Okay.
And that was done. She cashed the check. It's done. Like
Yeah.
she calls up a year later and says that she found out through the program somehow that they overpaid. Even after she moved out, they paid for another month or two, and she wants that money back, and they said they don't want it. So I had to
Wait.
Yeah.
Who doesn't want it?
In other words, if the program overpaid, and so I guess the same thing could be for, here's my question really, security deposit.
yeah.
Program pays your first month's rent and security deposit. Tenant wants it back, but sometimes the program has you sign a thing saying if you give it back, you'll give it to the program, not to the tenant. So how does that really work? Because that money didn't come from the tenant, but it was credited on the tenant's behalf, so whose security deposit is it?
I would talk to the program about that one. Oh,
I called and actually found out it was a rapid rehousing program, and the tenant was demanding the security deposit, and I had gotten it back from the program, and I wanted to be sure that I didn't give it to her, and then they asked for it.
Yeah.
So I made some calls to find out, and they said, please send it back to DC Housing.
okay. This is what I can tell. This is very elaborate. This is a very elaborate what I'm about to tell you. Under civil procedure rules, if you mean to give someone, if you're not disputing that money is coming to somebody, but you don't know who it is, you can actually file, it's a specific type of suit that forces people to duke it out. We're not going to get into that, but I'm just saying, theoretically, there are ways to resolve that. I would talk to a housing provider attorney.
Pay it to the person who paid you. And if they don't want it, then they can tell you that you can release it to the tenant, but get permission from the person who paid the security deposit.
Yes, get everything in writing. If you got nothing to hide, get it in,
What-
period. Follow what the rules are.
Well, it comes from the program, which is rapid rehousing, but they get it from the housing department, DC Housing. So housing wants it back. Rapid rehousing is telling the participants that they could keep it, which is confusing. And then the other point was, when they gave me the security deposit, it showed up as income. They gave it to me not as a security deposit, but it showed up on a 1099. So you have to be careful.
Okay, the security deposit is not income to the landlord. That is a protected asset that needs to be accounted for. Yeah.
But they're probably giving it to you as income because until you get it back, then you reclassify it as
No,
something else.
no,
Yes.
that must not,
Well, sorry. Oh.
no, that money does not belong to the landlord. Or, that money belongs to the tenant unless and until the deposit is used to defray legitimate expenses. It is literally a security deposit. And the tenant gets back every cent plus interest. Oh,
I'm sorry, so the question I really had is, can't we put in the lease that if you, because we have something in our lease that says, you know, when we accept, say, a Section 8 or rapid rehousing, that we will accept their letter saying that they will give us first month's rent and security deposit as, even though we don't have the first month's rent and security deposit, we'll let you move in, accepting their letter saying that they're going to pay it, you see, and then we'll let you move in. So the point is, can't we say in the lease that if your security deposit is given by a third-party entity, that it will be returned to that third-party entity?
I would talk to a housing provider attorney before doing that. I get that I may sound frustrating on this, but confusion or doing it incorrectly doesn't help anybody. And then, Oh, beware of a rolling security deposit. A landlord may charge the security deposit once. If the tenant is there for 30 years, you get one security deposit. Even if the rent goes up, the landlord is not allowed to ask that the person top up the security deposit to account for the increased rent. Was I incorrect?
We also see rolling security deposit used slightly differently in group houses where students are cycling in and out, where the student who's leaving takes a security deposit from the student who's moving in and taking their place. That's also a no-no. Don't do that.
I consider that daisy chain. Sorry, so when it said rolling, I thought that meant, okay.
Oh, it could be either, but both are bad. Don't do that.
The buck stops with the landlord. If the landlord wants a security deposit, the individual tenant should be paying the landlord. When that person leaves, should be between them and the landlord. Someone had a question?
Yes, real quick. The security deposit is used for damages after they've moved out.
Correct.
So how are we handling damages during the course of the lease?
It's going to depend on what the lease says. If someone, put it this way, as I said on a radio show the other night with the chief tenant advocate, no one has the right to destroy someone else's property. If a tenant does that, if a tenant causes damage to the property, you know what? Okay, so let me rephrase, can I attempt to rephrase your question? Are you saying, can the landlord during the course of the tenancy deduct from the security deposit? Leases say that, and the fact of the matter is if someone damages someone's property, they are accountable for it, whether or not contracts waive things, and then there are rules about whether or not you can do that. As far as can you take out of the deposit during the tenancy and how do you charge for damage, I would talk to a housing provider attorney about that because also if the issue were to end up in court, that can get what you're asking can be extremely fact specific. So I'm sorry if I'm, yeah. All right, was there yes,
Yeah.
ma'am.
Okay, so I just wanted to understand about the rolling deposit or whatever. So in the case of a person that is doing an upgrade at your property, say they've gone from a one-bedroom unit to a two-bedroom unit, and you're doing a new lease.
Okay,
Am
all right, so see, that's
That's an exception.
well, I wouldn't call it an exception. If a person is moving units, are they entering into a new tenancy?
Right.
When someone stays on in the same unit, they haven't entered into a new tenancy. And furthermore, even if they sign a new lease for that unit, they haven't changed the tenancy. They may have changed the terms of the tenancy. If someone is changing units, that strikes me as a new tenancy. But again, I would talk to a housing provider attorney because if there is any inkling that it is the same tenancy, it is unlawful to be demanding an additional deposit.
So you can't refund the original and under the new lease have the, like if you're going, if it
Are you
was
talking about
$1,000 and now you're going to $2,000.
A different unit or the same unit?
A different unit.
A different unit. Here's the thing. Again, in here, I'm going to ask Ramona this question. She has a great question. You can't charge. Let's say that a tenant moves to a different unit in the building, and there's a new lease. Can they require a different security deposit? If it's a different tenancy, then it's a different tenancy.
So if you want to do that, you have to completely close out the first one, which means you have to fully refund the security deposit, do
Okay.
the move-out inspection, and then this new tenancy gets to be its own new thing. If you want to do like a transfer fee, then you don't get to top off the security deposit because you're just moving someone from apartment A to
Right.
apartment B.
So you can do a transfer fee, which is a fee, not a deposit.
Yes.
For moving.
And that's, yeah, that, oh. All right, next slide. Okay. All right. Let's do what, we're going to do a little quiz here. Under what circumstances will a judge likely affirm a housing provider's decision to withhold Wilma Wear and Tear's security deposit?
We'll make another call when we take that 11 o'clock break, and if there's another one, we'll come find you.
That's okay. All right. So, in the following circumstances, something happened, and the landlord says that they are going to be withholding the deposit. Will they be allowed to do so? So, scenario one, Wilma vacated 3 months before the expiration of her lease term and did not give any notice. Will the landlord be allowed to withhold the deposit? Yes. Wilma left a light scuff on the wall while moving out her mattress. Will the landlord be able to withhold the deposit for that? No. 30 days after Wilma vacated, the housing provider mailed her an itemization of the cost to repair a hole Wilma left in the wall. Allowed? Yes. Oh. Why did you say? Why did you think no? Oh, I'm not trying to put, not you, someone behind. Oh, that's okay. No. Because the landlord did that within 30 days of Wilma vacating, so that was within the allowable time. All right, last one. Wilma threw. Oh, yes, ma'am.
When they withhold any any portion of the deposit, are they required to give itemized receipts as well for each item, or?
Okay. I would say as a best practice, if I were a landlord attorney, give the receipt. I mean, because all you're going to do if you don't give the receipt and it was a legitimate payment for that, that's just going to make the tenant more likely to want to litigate the issue. So the law does not say receipts. The landlord certainly has to explain why, but frankly, if this is a legitimate withholding, there should be a receipt to have paid for whatever it costs to repair. Give the receipt. Even if the person's not required to, I would be hard-pressed to say, why wouldn't you? All right, so the next scenario. Wilma threw a going-away party and completely trashed the unit. Unfortunately, things like that do happen. The housing provider kept the security deposit, but never mailed Wilma any notice. Yes. Again, that is such an avoidable scenario. If the landlord is dead to rights, going to be able to withhold it, follow the requirements. All right.
I have another question.
Sure.
With the first one, you said if she vacated 3 months before the expiration of her lease term without notice.
Yes.
Is there any amount of time that they can vacate early and be able to get their deposit back?
Okay. Without notice, I'm going to read that to mean that she had no legitimate excuse, like there were no housing code violations, she just decided she wanted to go. Then, if that's the case, then the landlord, if the tenancy is terminated, the landlord can withhold from the deposit for legitimate expenses. Unpaid
if the
rent.
tenancy is terminated?
Yes.
So if the landlord decides that they don't want the tenant to
Okay,
continue?
it's going to depend on why. The landlord cannot just terminate the tenancy because they feel like it. They have to have cause to do so. So once the tenancy terminates, the 45-day clock starts. So for the first example, the landlord is required to still send a notice to Wilma saying that the deposit is being withheld. I mean, again, it may sound like a technical requirement, it may sound like obvious, but it's a requirement.
And if
there's
the tenant decides that they want to leave before the lease agreement is up and they notify the landlord in writing, I guess,
Mhm.
do they have a right to, I mean, are they able to leave and get their security deposit back?
Under current law, if the tenant, what reason is the tenant providing?
Maybe they don't feel comfortable in the neighborhood or,
Okay, so it depends on the circumstances. If the tenant can claim that they have been constructively evicted, I think that might be getting a little too fact specific for this presentation. If the tenant vacates prematurely, the law does require the landlord to try to, it's called mitigate damages, lessen the impact. The landlord has to make a good faith effort to try to re-rent the unit. The landlord can't just simply sit back and say, oh, you have 3 months left on your lease, I'm going to send you a bill for 3 months rent, and I'm just going to sit back and not do anything about it. So, yes, sir.
What happens in a situation where the tenant gives a notice that he or she will be moving out in July, but moves out in August and doesn't pay rent?
If a tenant gives notice and then does not move out, the law currently reads that the landlord is allowed to charge double rent. Careful. Talk to a housing provider attorney if a tenant does that. Whoa, okay. Here, we'll start here and here.
Okay, I'm always confused.
No. Let's see if we
Okay.
can solve that.
Going back, because I had a situation like this. When a tenant, for whatever reason, decides upon themselves that they're going to vacate under a lease, they're just going to vacate.
Even though
And-
there's time left on the lease?
Yeah, 11 months.
Okay. Okay. All
And-
right.
Well, okay, and they've left and they said, well, you've got my security deposit, you can keep my security deposit, even though the lease clearly says security deposit is not to be used for rent.
Okay.
Okay, wait a minute. Okay, so my understanding, or at least this is what I had advised my owner, is you technically still don't have possession. You still have to go to court because you don't have possession and I can't lease this unit. So what I heard, and maybe I didn't hear it correctly, is that you, as the owner, you have to make good faith that you're trying to rent out. How can you do that when you
Okay.
don't have possession?
First of all right. We were presupposing here that the tenant vacated. They terminated their tenancy. They did something along the lines of, here are the keys. I am out of here. So there's no dispute that the tenancy wasn't terminated. Here's what happens. When tenants have asked, I have explained to them, the law does not entitle you to terminate the lease under the circumstances that you have presented. However, if you are going to leave, the worst thing you can do is to not tell the landlord, because the duty to mitigate isn't going to be triggered if the landlord doesn't know that there are damages, or shouldn't have known that there are damages to mitigate in the first place. So the scenario that I was describing presupposes that the tenant has vacated and has said they have terminated their tenancy.
And by vacating, meaning that all of their stuff is gone.
Ugh, not necessarily. I was going to say, this is one of those things, when in doubt, talk to a housing provider attorney. You do not want their, oh, sorry.
Oh, we can get into early lease terminations when we get to evictions. So don't worry, we can get into that topic then. Does anyone else have security deposit questions?
Yes, ma'am.
Security. He said, give them back your keys. If they do not give you back your keys, even though they vacated and they told you it was going to vacate it, are they truly vacated?
How do you want to answer that?
We'll go into it when we deal with evictions. We'll deal
Yeah.
with all the ways that you can terminate
Yeah.
a tenancy, and we can hopefully get the big picture and then the little
Yeah.
exceptions.
Like I said, I would be telling a tenant if they are determined to vacate that they be extremely unshy, that they specifically say, here are the keys, I am out of here, and they say so by certified because the thing is, if they want to trigger the landlord's duty to mitigate, they need to be very specific about it. So, let's move on to the next slide. Did we do this one already?
No, but you did talk about it.
Okay, so when a tenant pays rent, unless the tenant pays by personal check and has paid the full amount with no outstanding balance, the landlord must provide written receipts for all monies paid by the tenant as rent, security, or otherwise. The receipt must state the exact amount received, the date that the money was received, the purpose of the payment, and the amount in nature of any amount still due.
That's every payment.
Yes,
Every time they come in and hand me a check, if it's only partial rent, I've got to tell them all that.
precisely. That's what the law says. You have a question?
Yes. What if they pay irregularly?
What do you
I had
mean?
one that would pay this month, not pay next month,
Mm-hmm.
then pay me 3 months, and then not pay. So
At the time that they pay you, if they, with whatever they pay you, if they are not going to be completely current, the receipt should say what money is still owed. For example, if there's a late fee, which may or may not be allowed to be charged under the circumstances, but when you say irregular, if the person is paying you money and they still have an outstanding balance, then you would have to account for that.
okay, but if you pay me, you don't pay me this month.
Yeah.
Next month you pay me 2 months,
Yeah.
which would make it even.
Yeah.
And then the next month you pay me 3 months, which means I'm not going to see you for 3 months. So am I now? I couldn't really charge you late fee because you paid me.
Okay.
And then when you pay me early.
This is one of those things where I would just say, kind of like with the disclosure forms and having a written lease, it's probably a best practice to just provide a receipt. I feel like this is one of those things where why not give them a receipt? The last thing you want is a dispute, because if the tenant, we'll get to this when we cover evictions, when tenants get taken to court for non-payment of rent, the landlord does have to account for whatever money they claim hasn't been paid. So I would say I would give a receipt any and all times. If you want to parse the situations of are you not obligated to give a receipt, I would talk to a housing provider attorney.
And I would say with your irregular paying tenant, you're going to want to give them a receipt and keep a copy of the receipt and write which months they are paying for. It'll make it easier if, heaven forbid, down the road you got to sue them for non-payment. And they're like,
Yes.
I paid you 3 months rent that one time, and you're like, that was for June, July, and August. You didn't pay September, and so that's why we're here. Or you didn't pay May, you paid June, July, and August. So I would say always give that person receipts, because that person doesn't keep good records. They won't know.
All right, actually, I saw his hand up first. I'll get to you after.
Could you go back to that real quick, the one with what you have to have on the receipt?
Oh, sure.
Yeah.
And that's in your binder.
Okay. My question about that too is, do you have any idea of what a penalty would be if you didn't do that? I mean, because we give a receipt, but I usually put partial payment because I don't want to be specific, because it's hard for me to go back into their QuickBooks file and find exactly how much they owed and didn't owe. And
All right, so again, I'm not unsympathetic, but I have to tell you what the law says, and this is what the law says. The penalty is a landlord could get fined for doing that.
fined by the court.
Yeah, or, well, the regulatory authority involved. The bottom line is the law says what it says, and like I said, I'm here to say what the law says, not what it should say, and not to, and again, don't confuse that with me not being sympathetic. Yeah, she had her, here, I'll get to you after. And
Aren't you
then
changing,
you, and then we should move on.
if the
Yes.
lease requires payment on a monthly basis and you're trying to be nice and you're taking partial payments or payments every few months, aren't you changing the terms of the lease? Isn't that making you more, putting you in a difficult position? Should there actually be an issue where at some point they're going 3 months and 4 months and 5 months or something like that?
Okay, so just because someone most leases, and this is why it's a good idea to have a written lease, most contracts for that matter tend, as a matter of boilerplate, to have a clause that says the fact that one party may waive enforcement of a particular clause at a particular time is not to be construed that they are forever giving that up. There is case law about what happens if a landlord acquiesces for a while to something but then decides to enforce the term. The fact of the matter is, what's the old adage, no good deed goes unpunished? It may unfortunately be best business practice to not be so forgiving about that situation.
Is
All right.
somebody else before me?
No,
I
you,
just had a quick-
sure.
I asked that, hopefully I didn't forget it. Does this apply to all landlords? Or is anybody exempt, like 4 units and under? Or
From the receipt requirement,
all-
no,
Everybody, okay.
no. Oh, yes, there is no exception.
There is no exception. Okay, that was my question.
Okay, ma'am?
Maybe you've already discussed this, or maybe you'll discuss it later, but
Okay.
business licenses, have you covered
Business,
that?
that we covered that at the beginning.
Okay.
During
Then
the
I'll ask
break,
later.
we can, all right. All right. So we briefly discussed rent control. Rent control limits the amount and frequency of rent increases. All residential rental units are subject to rent control, except those that are excluded or exempted by statute. There's a difference between an exclusion and an exemption. There are 7 rent control exemptions. The most common are: the unit is located in a building constructed after 1976. The unit is owned by an individual, not a business entity. An example of a business entity is ABC, LLC, INC, anything where you have alphabet soup after the business name. The individual also must own 4 or fewer residential units, rental units, or if the unit is subject to a federal or DC government subsidy. Important, if the landlord has failed to properly register for an exemption, rent control does apply. Frankly, if someone is exempt from rent control, if someone is eligible for an exemption, they should be applying for one. There is really, it's just going to cause grief later if the person doesn't file the paperwork. Yes, sir.
So
and
my
then I
question
see-
is, I've heard different things over the years from rent administrators and from lawyers.
Yeah.
So if I have my 4-unit building, let's
Yes.
say, and it's under rent control, if I want to, I get it empty, I tear it down, I build a new building, I'm no longer under rent control?
That when a unit is demolished or when a new unit is built, when there was a partial demolition, that can be very fact specific. I don't have the code in front of me. I would look that up, and frankly, if the landlord is entitled to seek an exemption, in here, I'm going to say this right now, even if the landlord is dead to rights eligible for an exemption and thinks that there is no argument why they would not be, fill out the paperwork. It's really simple. RAD Form 1, get an exemption number, be open and notorious about it, print it in big letters on the disclosure forms, be very transparent about it. Yes, ma'am.
Once you have registered for the exemption,
Yes.
are you good until you go over 4 or more, or do you have to re-register
Okay.
every time you get an additional unit?
When a person, if a person, the way that the law works, a unit can't, rent control, even if it's the owner who is claiming the exemption, rent control, the rent control status of a unit is unit by unit. Units can go from exempt to rent controlled, they can go from rent controlled to exempt. So it really depends on the particular circumstances. If a housing provider owns 4 units and then they acquire a 5th one, they're no longer eligible to be a small landlord. So then presumably they would already have had the paperwork on file to cover the previous situation. But yes, whenever there are changes, there may be an amendment form that needs to be filed. That's a question that should be addressed to the rent administrator's office. But there are a lot of technical requirements. Was there another question, or can I move to the next slide? Okay.
So if I have, a 20-unit building,
Yes, you're not a small
well,
landlord.
no, owned by a corporation,
Ah,
and then I own 2 somewhere else, clearly I'm a sophisticated landlord, but, because I've heard that before, that I own too many units, but it's the corporation that owns it.
well, not the way that we don't have the code in front of us. It also includes having an interest in the unit. Yes, I'm not accusing you of doing anything crooked, but people do try to, it would get too bogged down on details, but there are rules about that. There's a screen for the caption, so I'm gonna stop for a second. Yes, ma'am.
Okay, so as far as rent control,
Yes.
what is rent control? It just means you can't go up, is there a
Rent-
percentage, or I don't
Okay.
know, what is that?
First of all, to be able to raise the, pardon?
Next slide.
Oh, it's the next slide. Okay. And here's the thing, even if the unit is rent controlled, if paperwork is not current, the rent might not be allowed to go up at all. We're going to get to that on the next slide.
Oh,
Okay.
and
Oh.
just a heads up, this is going to be our last slide before the break.
Okay. All right. For any and all rent increases, whether or not the unit is exempt or under rent control, the landlord must provide a 30-day written notice. If the landlord has given less than that, the rent increase may not take effect that month, and the landlord has to wait. The amount of the allowable rent increase depends on whether the unit is subject to rent control or other rent limitations or not. If a unit is under rent control and all the other requirements are complied with, the rent increase is limited to once every 12 months and cannot exceed the consumer price index plus 2%. Now, in the event that there's ever very high inflation, that number can actually never exceed 10% for this type of increase, once every 12 months. If a tenant has registered as elderly or with a disability, the amount is the lesser of the consumer price index, the Social Security cost of living adjustment, or 5%. The Rental Housing Commission around, I believe it's February of every year, releases an order that states what the increase of general applicability is, and that is for rent increases taking effect on the upcoming May 1st. Subsidized units, for example, Housing Choice Voucher Program, Low-Income Housing Tax Credit, Affordable Dwelling Unit, Inclusionary Zoning, also have limits on the amount and frequency of rent increases. Those, however, are governed by the laws that govern each specific program. If the unit is exempt from rent control and there's no subsidy involved, the increase is limited by what the lease says or what the market says. All right. Oh, and I think we're going to take a break. Here, your question, and then we're going to go to break.
So, let me see.
Okay. Oh.
Well, when you increase, so you're not allowed to increase rent between your lease period. You can only increase rents
I
at
don't.
the end of a lease period, but
No, all right,
given
so here's the
30
thing.
day-
If we're talking exempt from rent control, there is no law that forbids a written lease from saying that the rent will go up in the 6th month of the 6th month of the lease. It would depend on what
Even
the
though you
lease
have a
says.
written contract saying you're going to pay this amount for this amount of time.
Well, but I'm sorry, but I guess the way that you're phrasing your question, you're saying then the contract could say that the rent will be X amount until X date, and then it will go up to this amount during a lease period. I can't say that I've seen that very often, but that doesn't mean that it's not lawful to do that. Well, usually what would happen is leases will sometimes say what the rent will automatically go to in the event that a new lease isn't signed. Be very careful about that. If the unit is under rent control, or if the landlord does not have the proper compliance to be exempt from rent control, that can be construed as an unlawful demand for rent. So the moral of the story, one of many morals, is always be in compliance. Always have current paperwork.
But with a new renter, you can raise the rent for the next person. We don't have to keep it in.
If it's under rent control, there are rules that regulate what are called vacancy increases. I don't know if we get that do we get that specific here? Okay. But there are rules about that. If it's under rent control, the rent may not, there are caps to that.
And
Yes.
if you wanted a more in-depth discussion of rent control in the district, the Department of Housing and Community Development has a really great pamphlet that they updated last year.
Yeah.
And it's like 10 pages, and it goes into the statute, it goes into what the rent increases can be, it goes into vacancy increases, it gives it to you all in great detail, and it's on their website,
Yeah.
dhcd.dc.gov. And if you go to rent control, it's like one of the options you can choose. It'll give you all of their information about it, including their forms.
Yes. All right, and with that, I think we will take a
10-minute break?
10-minute break. All right.
So see you guys
See you
at
back in
11:10.
10 minutes.
Yeah.